Americans have reported a wide range of troubling encounters with immigration agents. When the Supreme Court recently allowed immigration agents in places to take race into consideration during sweeps, Justice Brett Kavanaugh said that citizens shouldn't be concerned. So does immigration personnel have the right to arrest American citizens? Legally, no. By the letter of the law, ICE only has the authority to detain, arrest or deport people who are believed to be in the country illegally, or those under reasonable suspicion in which race can be a factor but not the only factor, of interfering, obstructing, impeding immigration processes in the field. Questions asked by immigration personnel in the field. Are you a United States citizen? Where were you born? What hospital were you born? What high school did you go to? What college did you go to? Where do you live now? Where were your parents born? Don't appear nervous, like that's possible. Can ICE qualified immunity be attenuated? Short answer, only in rare, extreme circumstances, and even then, courts often still uphold immunity. 1. Violating the Constitution does not automatically remove qualified immunity. Courts have repeatedly held that even when ICE agents violate the Constitution, they often still receive qualified immunity because federal courts have sharply limited lawsuits against federal officers, Bivens restrictions. Courts require a clearly established precedent with nearly identical facts, which is almost never met in ICE cases. So, a constitutional violation is necessary but not sufficient to defeat qualified immunity. 2. Violating ICE's own rulebook or protocol also does not automatically remove immunity. Courts treat internal policies as guidelines, not enforceable rights. Sources show, ICE agents have been granted qualified immunity even when they broke internal rules or used force outside protocol. Courts say internal rules do not define constitutional standards. So, breaking protocol, losing immunity. 3. When can qualified immunity be weakened or denied? Based on recent cases and analysis, A. When conduct is plainly incompetent or knowingly unlawful. This is the Supreme Court's own standard. Examples from recent reporting: ICE agents who arrested U.S. citizens illegally, ICE agents who used force on children, ICE agents who caused crashes during reckless pursuits. Even in these cases, courts still often upheld immunity, but these are the types of facts where attenuation is possible. B. When the Supreme Court signals a narrow opening in 2025, the court hinted that some ICE misconduct may be actionable under Bivens-type reasoning in extreme cases. This is not a guarantee, but it's the closest thing to attenuation. C. When Congress intervenes. There is an active bill, H.R. 4944, ending qualified immunity for ICE agents Act. Not law yet, but it shows the legal landscape is shifting. For the practical reality, based on the data, hundreds of people released after courts found ICE violated the Fourth Amendment. 0 agents prosecuted. Courts routinely dismiss civil suits because of qualified immunity and Bivens limits. So the real-world answer, attenuation is theoretically possible but extremely rare. ICE agents receive qualified immunity unless both conditions are met: a constitutional right was violated, and that right was clearly established in prior case law with highly similar facts. If either element fails, immunity stands. Constitutional violations. A constitutional violation is necessary but not enough to defeat immunity. Courts often acknowledge a violation and still grant immunity because no prior case had nearly identical facts. Bottom line, a violation alone does not attenuate immunity. Violations of ICE policy, protocol, or rulebook internal rules do not create enforceable rights. Breaking protocol does not affect qualified immunity. Courts treat agency manuals as guidance, not legal standards. Bottom line, protocol violations. Loss of immunity. 4. When attenuation may occur, rare, qualified immunity becomes vulnerable only when conduct is A. knowingly unlawful. The agent understood the action was unconstitutional. B. plainly incompetent. The conduct is so unreasonable that no trained officer could believe it lawful. C. fits within a narrow, previously recognized Bivens-type context. Federal courts rarely allow this, but it remains a theoretical path. Absolutely. Here's the clean, concise explanation of a Bivens-type context, grounded directly in the sources you pulled. Bivens type context. Concise definition. A Bivens type context is a very narrow category of situations where a person is allowed to sue a federal officer, not the agency, for violating the Constitution, even though no statute authorizes the lawsuit. It comes from the Supreme Court's 1971 decision Bivens v. 6 Unknown Named Agents. Courts will only allow a Bivens claim when the facts closely match one of the few situations where the Supreme Court has previously allowed such suits, and no special factors suggest the court should stay out of it, example immigration enforcement, national security, or Congress having chosen not to create a remedy. Because the Supreme Court has repeatedly restricted Bivens, almost any new situation is considered a new context, and courts refuse to extend the remedy. The three accepted Bivens contexts courts generally recognize only three: Fourth Amendment, unlawful search/seizure, Bivens, 1971, Fifth Amendment, gender discrimination, Davis v. Passman, Eighth Amendment, deliberate indifference to medical needs, Carlson v. Green. Anything outside these is usually rejected as a new context. Why this matters for ICE immigration enforcement is treated as a new context with special factors: foreign affairs, national security, congressional silence, so courts almost always refuse to extend Bivens to ICE misconduct. Bivens type context equals one of the few, narrowly defined situations where courts allow lawsuits against federal officers for constitutional violations. Anything outside those narrow precedents is almost always dismissed. Note, even in extreme misconduct cases, courts often still uphold immunity. 5 practical reality lawsuits against ICE agents face 2 barriers: qualified immunity limits on suing federal officers, Bivens restrictions. Most claims fail at one or both stages. Result: attenuation is possible in theory, exceptional in practice. 6 legislative landscape. Congress holds the power to modify or eliminate immunity for ICE. Bills have been introduced to limit it, but none have become law. Quick reference summary: Constitution violated, required but insufficient, protocol violated, legally irrelevant, attenuation, only for knowingly unlawful or plainly incompetent acts. Most outcomes: immunity upheld. Why? Lack of clearly established precedent plus federal officer limits. Summary: qualified immunity for ICE attenuation rules. Constitutional violation? Required, but not enough. Protocol/rulebook violation? Irrelevant to immunity. Attenuation possible? Only if conduct is knowingly unlawful or plainly incompetent. Most cases. Immunity upheld due to lack of clearly established precedent. Future changes? Possible only through Congress.
It's a sign of the times.